All right, let's roll. Attorney Steve Vondran. Welcome to another exciting video. We are talking about contracts. This is going to give you a quick starter course into contract law. I have my website up here, Contract College, if you need some more information. But what I'm trying to do is I'm trying to take, when you're a first-year law student, I can't get this pen open. When you're a first-year law student, you take a full year of contracts, 1 full year. Now, that's a long time if you think about it. Attorney Steve doesn't have, I know you don't have that kind of time. You're busy. You got things going on. So I am going to try to break this down, contracts law, into 10 episodes. This is number 1, okay? So let's go over here. Let's take a look. Contractcollege.com. Let's get that there. So I'm just building this website. It's been going. I have some good stuff already. There's going to be more. But I'm talking in this video about forming the contract. Episode number 1. This is going to give you the real basics of contract law. Stuff even if you're going to law school, this is what you want to know. So contract law is really, to me, kind of this simple. This is kind of the very simple structure of it, okay? Number 1. You have in every contract situation, and first of all, before I go into it, my professor in contracts, who was from Harvard Law, and said this: a contract is a promise or a set of promises that the law will enforce or provide a remedy for, okay? A promise or a set of promises that the law will enforce. Now, that does not sound too tough, does it? Really, the reason we have contracts is so people can do transactions, predict their future. I'll contract with you to build out my website for X amount of dollars. I'll contract with you to do celebrity endorsements on your TikTok. On and on. I'll contract you to play baseball or basketball or football for the next 5 years. Contracts is a part of everyday life. Even when you go on the internet and you click something and it says, click I agree, that you have read the terms and services. You know you didn't read those terms and services. And if you did read them, you wouldn't know what they meant and so forth and so on. But you're forming contracts. You're forming contracts that the law will enforce. So you need to think about these things. But it's very simple. Let's take a look. You have an offeror. That's the person making an offer of certain terms. I'll buy this, I'll do that. I'll buy, as we say in real estate class, I'll buy Blackacre for X amount of dollars. I'll buy that lot of land. And you're making an offer to an offeree. In law, the person who receives something usually ends up with the E, okay? The one who's doing something, making something towards someone is usually the offeror, the promisor, okay? The lessor, the leasee, the promisee. You see what I'm saying? So law is good that way. It's consistent that way. So the offeror is making an offer to the offeree, and I have up here just kind of the basics. Certain and definite terms. What are you making for the offer? How much? What are you planning to do? Will you sell me the lot plus your refrigerator and the pool table? That's my offer, and I will buy it for $1 million. I will buy your property for $1 million, but you've got to throw in the refrigerator and the pool table. You have to have legal subject matter. You can't do like a contract killing. I mean, you could, but it's not enforceable. Things that are dealing with illegal subject matter, something that's illegal, not enforceable, okay? Identify the parties and the duties. I always tell people, look, when you were trying to create a contract, they say, well, how do I even draft a contract? I don't even know. Set forth all the things that you're expecting the other party to do. Put forth all the duties, okay? Everything you're expecting out of the contract. And then the other party say, well, since you're doing that, why don't I do that in return? Here's everything I want out of you. So it's really not that tough, and really a contract is not a lot more than that. So identify your parties, identify the duties. If it's like a contracting agreement, a project manager, set forth your timelines, your milestones, whatever the situation may be. 4, you want to make sure the parties have capacity, mental capacity to contract. This is where in law school you get into the issue, can somebody 13-year-old entered into a contract? Yeah, they can. Problem is that they can terminate the contract at their will all the time up until they're the age of majority, 18 in most states, unless it's for necessaries, food, shelter, clothing, things like that. So anyway, make sure the parties have capacity to contract. You don't want somebody who's, let's say, 95 years old and is diminishing in quality, and there's a sign here, that can become a capacity issue on the enforcement of the contract at a later date. And breach, set forth what is a breach. You need to do it by this date. You need to pay by this date. If you're in escrow on a lot, the money's going to go hard on this date. You need to say what happens if it doesn't. Sometimes in my piracy defense practice, it'll say, if you do anything wrong to breach this contract, you will pay liquidated damages. And I have a video on liquidated damages clause. But so you can provide for things. You can provide an arbitration clause. What happens if one party breaches? We'll go to arbitration. We can have the winner gets attorney fees. We can say, no, the winner doesn't get attorney fees. This is where negotiation comes in. You negotiate your terms of your contract. But if you have the offeror making a good, legally enforceable agreement, promise, or set up promises the law will enforce to the offeree, and the offeree accepts verbatim, you have an enforceable contract, assuming there's consideration. I'll talk about that in 1 second. But that's all you need. Offeree, offeror, capacity, subject matter, terms. It doesn't have to be in writing. Oral contracts are enforceable as well. Problem is they're a lot harder to prove. And I don't like oral contract cases myself because it's he said, she said, red light, green light. So offeror, offeree. Now, here's what typically happens. If it's an acceptance, it's an unequivocal manifestation of an intent to be bound by these terms, then you have a contract. However, what typically happens is you have what we call the mirror image. If the offer says, fine, I'll throw in the refrigerator and I will give you the pool table, everything you asked for and $1 million, I'm not even going to counter you. Now you have an enforceable contract. However, usually what happens is negotiation. Somebody says, no, I'm not going to give you. That's my favorite pool table, man. And by the way, $1 million, too low. Give me $1 million too. No, I'll give you the refrigerator. No pool table. So this person makes what's called a counteroffer. The counteroffer rejects the offer. Counteroffer rejects the offer, becomes a new offer. Now this person who was the offeree is now what? The offeror, and this person becomes the offeree. See how it goes? This is not incredibly complex here. So they make the counteroffer, rejects this offer. It's a new offer. Now, if this person says, you know what? Fine, I'll take the $1 million too. I don't need the pool table. You throw in the fridge? Okay. Now, when they accept a mirror image acceptance, no additional terms, unequivocal manifestation of an intent to be bound by the contract, you have a contract, okay? And it's really that simple. Now, I have down here Statute of Frauds, SOF. Some contracts have to be in writing to be enforceable, like real estate. You can't go get a mortgage loan agreeing to borrow and do this, pay back money, or buy a house. Those things need to be in writing. I'm not going to go too much into depth. I have another video on Statute of Frauds. Attorney Steve, Statute of Frauds. Google that, you'll find it. Finally, the one thing you have to make sure, now all this, we got it in place. The last thing to make sure is that there is legal consideration. Now, usually there doesn't have to be anything fancy, but there has to be a quid pro quo. This person is bargaining for this. This person is bargaining for a promise. So I'm bargaining for a promise. I'm bargaining for an act. And that's where you have unilateral and bilateral contracts, okay? I'm not going to go into depth. I don't want to confuse anybody, but we can get a lot more complicated here. But consideration is what we call the glue that binds the contract, makes it enforceable. So it's a quid pro quo, and it's a bargain for exchange. We're exchanging this for that. If you have all this, my friends, you have a contract now. This is general terms only, not legal advice or substitute for legal advice, but this is the general. Step one, how do you form a contract? Here it is. I just saved you probably 2-3 weeks of law school right there. Offer, offeree, acceptance, counteroffer, mirror image rule, consideration, statute of frauds. So that tells you what a contract is, how it's formed. Okay, so that's video 1. I'm not going to give you any intros into 2. Just make sure you subscribe. You get through all 10 of these videos, you'll walk into contracts law class, and they'll probably go like, how does this guy seem to know everything? And I have to brag a little. I am contracts with my Harvard law professor. Attorney Steve, your favorite. Make sure to bookmark me, subscribe. Boom, punch that like button. Thanks for watching. I appreciate it. Have a great day. Bye now.